Welcome back, everybody, to our lecture series in the subject of public international law. The previous lecture was concerned principally with the historical development of international law, thinking about some of its earliest developments all the way back to the early colonial period, and taking us all the way through to the turn of the 20th century. And that's where we finished our previous lecture. We finished our lecture thinking about the turn of the 20th century and the beginning stages of the First World War. Now, in this lecture specifically, we're going to be concerning ourselves with modern international law. Now, what I've termed and deemed to be modern international law is really just a continuation of the historical development of the subject of the field, but really thinking about the 20th century, because a lot of things happened in the 20th century, and we're going to go through the 20th century in this lecture and end up at the turning point of the 21st century, where we finish thinking about the war on terror. And then all the even more modern and even more recent developments in international law that we'll talk about, we'll examine for future reference when we think about the future of international law at the end of this entire course on the subject of public international law. So it's important to note that in this lecture, what we'll do is a quick recap from lecture 2. We will explore the First World War, the Treaty of Versailles, and the League of Nations, the principal sort of institutional organization that existed between the two world wars, the interwar years. We will then think about the impact of the Second World War, the establishment of the United Nations, the post-war justice system, so specifically thinking about the Nuremberg trials as a major inflection point of the development of international criminal law specifically. We will think about the impact of the Cold War, the fall of the USSR, and the ways in which international law develops in the 1990s, before thinking about the impact of the war on terror. There are a few things that we're going to miss throughout this series, of course, because this is a general introduction to the historical development of international law. Maybe in the future I will do an entire lecture series on the history of international law. Alternatively, I might just spend some time talking about the historical developments of particular fields of international law in those lecture series. So I will talk about the historical developments of international humanitarian law, for example, when we do a study on international humanitarian law specifically. Let's begin then with a recap and an introduction. And really what we finished in our previous lecture was the turn of the 20th century, the turn of the new century into the 1900s, and the beginning stages of the First World War. It's important to note that the First World War was one of the most important events for the state of international law, at least at the time, since it ostensibly led to the creation of a system of lawmaking and adjudication, a system that we actually rely on to this day, but we just rely on it in a different format and in a different mode. The sort of echoes of the League of Nations can be still seen in the development of the United Nations that we see at the end of the Second World War. But fundamentally, this system that is developed as the result of the First World War is a system which ultimately fails. And it would take a far greater and a far more impactful conflict to deliver a system of international law that we actually still rely on to this day and sort of holds out longer than the few decades that the League of Nations did. So the First World War itself was fought, of course, between 1914 and 1918, and it was principally a European war. With the support of course, European imperial subjects. So there is a sort of general focus that is associated with the continent of Europe when we think about the First World War, but this is not only the only location in which the war is fought, and it is not the only actors who fight in this war. There are also the considerations that we have to think about, that these are empires that are fighting, and empires, of course, have their own colonial subjects. Leading up to this conflict, then, European powers had been building up massive militaries in the years prior, with some founding states believing that there is this idea that national power is tied to military strength. For example, the reign of the German Emperor Kaiser Wilhelm II was very much situated with this belief that there is a clear link between military strength and national power. When we couple this with the establishment of two major European alliances, you have on the one hand the Triple Alliance, which represented Germany, Austria-Hungary, and Italy. And then on the other hand, you have the Triple Entente, which represented France, Russia, and the United Kingdom. The stage would ultimately be set for the interweaving of each of these great nations into conflict with each other. And it is precisely because of these kinds of alliances that draws more and more empires, draws more and more countries into the First World War. But it needed a triggering event. And all that was needed was a triggering event. And this was something that takes place in 1914. An immediate match to light, if you will. And it came on the 28th of June 1914 with the assassination of the Archduke of the Austro-Hungarian Empire, Franz Ferdinand, who was heir to the Austro-Hungarian throne. The assassination of Archduke Franz Ferdinand in Sarajevo by a Bosnian Serb nationalist by the name of Gavrilo Princip. Given that there are multiple alliances structured prior to this event, and there is the promise of protection of, firstly, Serbia by the Russian Empire, there is the reliance on the German Empire from the perspective of the Austro-Hungarian Empire, it soon became a very broad, very global, and a very specifically European conflict. So with the support of Germany, the Austro-Hungarian Empire issued an ultimatum to Serbia. Now, this ultimatum was ultimately unsatisfactory. Arguably, it was demands that they knew they were never going to accept. This is sometimes known as the July crisis, the crisis of the month of July. And the reason for this is because ultimately Serbia accepts most of these terms, but they also want to essentially have these this sort of response be negotiated at some kind of international adjudication in The Hague. And essentially the Austro-Hungarian Empire wanted a casus belli. They wanted a cause for war, and so they put terms down that were going to be unsatisfactory, that they knew they were never going to accept. And so what happens on the 28th of July 1914 is a declaration of war. A declaration of war which then sparks a chain reaction taking place, and soon both of the major alliances were all at war with each other. The First World War then had a major impact on the landscape of the European continent and the world more broadly, of course, and it's important to realise that even though I have said that this is a conflict that is centrally European in nature, due to the impact of imperialism, it becomes a globalised conflict. As Hawke notes, for example, although its origins were European, the war's global scope emerged due to combat on and over European colonies. So when we think back to our previous conversation from the previous lecture, we spent a lot of time talking about the impact of colonialism. And here is an example of how a principally European war becomes a world war, it becomes a global conflict because, quite frankly, of this issue of colonialism among all of these different European empires. And so when we get through the First World War, 1914 passes, 1915 passes, 1916 passes, and then a number of events takes place in 1917 that shapes the ways in which this war is going to end and the ways in which states and nations are going to look after this war has come to its conclusion. The first of these are, of course, the Russian revolutions of 1917. The Russian Empire will collapse into revolutions. Fundamentally, the Russian Empire doesn't have a particularly good time in the First World War. It has some temporary successes, things like the Brusilov offensive, but it also has major conflict failures, things like the Battle of Tannenberg. And when we get to the start of 1917, we can see that inflation is already reaching its highest peaks in the Russian Empire. You've got the fact that the Tsar of the Russian Empire, the king, if you will, Tsar Nicholas II, has taken over personally command of the entire Russian military forces, something that he is not qualified to do. And when there is the announcement of a further bread rationing in February 1917, a revolution then begins. The revolution takes place really in two stages. You have the February Revolution, which takes place in February or March, according to the Gregorian calendar, in which we see the abdication of, the overthrowing of the Tsar and the ending of and the collapsing of the Russian Empire. What follows is a period between the two revolutions of dual governance, in which you have the establishment of something known as a provisional government, alongside a different authority. This was known as the Petrograd Soviet, and they sort of both were vying for power and authority. But one of the things that was the most damaging to the provisional government was the fact that they made the silly decision to continue fighting in the First World War, having the June offensive, or the Kerensky offensive in June 1917, which ultimately reduces and collapses the faith and authority in the provisional government, and that's what allows the Bolsheviks, the Bolshevik Party, to come in and take over in October 1917, or November according to the Gregorian calendar. And this is where we see the establishment of the Bolshevik consolidation of power under Vladimir Lenin, and we see the complete collapse of the Russian Empire into the creation of the Soviet Union. This same year as well, the United States would join the war, and would join the war on the side of the Triple Entente with Great Britain and France, Russia no longer being a part of this conflict. At the time, Woodrow Wilson was the United States president, and Woodrow Wilson is a very important figure when we think about the development of international law, because not only do we see that the United States intervening in the European conflict as a benefit for the Triple Entente, but also Woodrow Wilson would see the intervention of the United States in the First World War as a potential opportunity for him to reshape the world order with a certain amount of American influence. And so he aimed to create a framework for lasting peace after the war had ended. This is why he issued what became known as Woodrow Wilson's 14 points, issued on the 8th of January 1918. Essentially, what the 14 points were a series of basic concepts and basic ideas for what a post-World War I world should look like. Now, there's a few within it. There's a total of 14, obviously, and some of them are relatively basic. So basic points such as the end of secretive diplomacy. That is his first point. That's the first of his 14 points. As well as the restoration of specifically Belgian sovereignty, which is his 7th point. But there are also some really important ones as well. One of which is, of course, his 14th point, which states that a general association of nations under specific covenants for the purpose of affording mutual guarantees of political independence and territorial integrity to great and small states alike. What does this mean? Well, it's kind of fancy language, it's kind of sort of old, esoteric, archaic language, but it is essentially a declaration for the establishment, a desire for the establishment of a League of Nations, a international organization in which all nations of the world will be part of, to basically be able to do open diplomacy, to resolve disputes peacefully, and to essentially be able to shape the world through this kind of diplomacy. Similar to how we have the United Nations to this day. So that is his major goal. His major goal is to see the establishment of a League of Nations. An additional one of his 14 points is the establishment of the principle of self-determination for states, which is fundamentally an anti-colonial endeavour and an anti-colonial structure. But we'll see that what ends up happening under the League of Nations is a kind of what we might describe as colonialism light, LITE specifically, a sort of type of colonialism that isn't quite the same as it used to be, but in many other ways is also just as bad as ordinary colonialism. We'll get to that in a second, because fundamentally I also want to talk about, before then, the Treaty of Versailles. So, we have the issuance of the 14 points before the end of the First World War in January 1918. This is what Woodrow Wilson wants to see the world look like after the end of the First World War. Now, for students of history, specifically students of the history of the Second World War, the Paris Peace Conference and the Treaty of Versailles of 1919 are significant, specifically for the terms that they imposed on Germany. Now, essentially, the Treaty of Versailles, the Paris Peace Conference, represents the formal ending, the formal cessation of hostilities at the end of the First World War. A very brief overview of what happens is, in November 1918, we see that the German government is beginning to collapse. It's beginning to revolt. It begins with the decision on the part of the Chancellor, Prince Max of Baden, trying to issue an armistice, trying to request an armistice from Woodrow Wilson secretly, which then causes quite a lot of revolting, quite a lot of mutiny. One of the first mutinies was at the Kiel naval base in Germany, all of which results in the abdication, the forced abdication of the Kaiser Wilhelm II on the 9th of November 1918, and he then flees to the Netherlands, and we have to see the establishment of a new constitutional system. This becomes known as the Weimar Republic, the Weimar government. The reason why it's called the Weimar Republic is because the constitution was drafted in a small town just outside of the city of Berlin called Weimar, and the reason why they had to meet in Weimar and not Berlin is because Berlin was under the auspices and under the guise of a revolt and a putsch at the time. So there was sort of revolution taking place in the capital, so they had to go somewhere else to try and figure out their constitution. And then formally, they request an armistice agreement, and they essentially surrender, which then obviously comes into effect on the 11th of November 1918. And the Paris Peace Conference and the Treaty of Versailles, which opens in 1919, is essentially the terms at which are going to be imposed on Germany. Germany was not invited to negotiate at the terms of the Treaty of Versailles. It was basically all of the major other powers. The major powers, of course, representing the so-called Big Three, were Great Britain, France, and the United States. Now, the Treaty of Versailles is seen as quite significant for many reasons, one of which is because they were deemed by many within Germany, the terms, as far, far too harsh. Now, this is, in my opinion, especially true of one particular clause, Clause 231, which is known as the War Guilt Clause. And what the War Guilt Clause essentially said was that Germany was solely responsible for starting the First World War, and as such would have to pay a massive reparations bill to the Allied powers. The reparations that would ultimately have to be paid, the number of dollars essentially that would have to be paid to the Allied powers as way of reparation, would require the establishment of a commission that would essentially set the number in 1921, and it's an eye-watering number, one that is difficult for Germany to even pay off. But for our purposes, for the students of international law, and for thinking about the historical development of international law, the Treaty of Versailles also is very important for its establishment of the Covenant of the League of Nations. The League of Nations was very, very important. Quote, the League of Nations was, in contrast to the preceding administrative unions, perceived to be the first political organization. This is a very important point. The League of Nations is a very ambitious project. The preamble to the League of Nations sets out the major goals that the League is looking to achieve. The preamble states, for example, that there is a desire to both promote international cooperation and to also achieve international peace and security. In this endeavour, then, it aims to prevent wars through something known as collective security, as well as global disarmament, and also to resolve international disputes between states through the establishment of a specific court. It was titled the Permanent Court of International Justice, or the PCIJ. Now, interestingly, the Permanent Court of International Justice used to sit and used to operate in the exact same building as the current International Court of Justice, the Peace Palace in The Hague. Now, this is important as well because some of the rulings and decisions of the Permanent Court are very, very important even to this day for some of the rules that are laid down in public international law. So we will come back to the Permanent Court of International Justice in future lessons' time, in future lectures, and when we think about specific cases. Now, tying our discussion from the previous lecture to this one, the idea of imperialism and colonialism, one cannot overlook the impact of the League of Nations on European imperialism specifically. And if we go back to some of the academic works that we relied on in thinking about the history of international law, according to Koskiniemi specifically, quote, "At the end of the First World War, popular opinion had turned decisively against formal empire. Territorial gains had also been excluded from the Allied war aims." So unlike conflicts that previously had taken place in the 1800s and prior even then, one of the war aims, or one of the spoils of war, let's just say, if for a winning power, might have been the colonial holdings of the defeated powers. Now, this was excluded explicitly in the League of Nations and through the Treaty of Versailles. And one of the reasons for this is because the United States, specifically Woodrow Wilson, believed in this idea of self-determination of all peoples. And so the United States represented almost a type of counterbalance against traditional imperialism, the traditional imperialism of European states. But this is not to suggest that there was the end of imperialism. There was the establishment of decolonization after the end of the First World War. And the reason for this is because there was a problem. Ultimately, the First World War had destroyed a number of European empires. It had destroyed the Austro-Hungarian Empire, it had destroyed the German Empire, it had destroyed the Ottoman Empire. And so what was to be done with the former colonial interests of these dead empires? Surely the most progressive and the most in line with Woodrow Wilson's principle of self-determination would be the decolonization of these regions, the granting of independence to these former imperial subjects. Well, the reality was not as such. Instead, the solution was a sort of soft colonialism. This is known as the League of Nations mandate system, and has been described by Suvala specifically as the, quote, colonial branch of the League. It was established under Article 22 of the Covenant of the League of Nations, and it suggested that peoples living under colonial domination of the collapsed imperial structures were considered, quote, peoples not yet able to stand by themselves under the strenuous conditions of the modern world. This is, of course, a quote that definitely makes very clear the kind of mindset and ideology of this white imperialism. This idea of white imperialism had not gone away with the collapse of these major empires and the development of a major world war, nor had it become less palatable like the formalistic empires of old. It represented a standard of civilization. Again, quoting Suvala, the wording of Article 22 indicated the provisional, transitional character of the settlement, thereby enacting the, quote, logic of improvement, the idea of the logic of improvement. The mandate system was not presented as an institution that would last indefinitely, but as a necessary intermediate stage for specific peoples who could not yet stand on their own. It's a very interesting structure. At no point in Article 22 And at no point throughout the sort of development of the League of Nations was it seen that the mandate system would be permanent, but it represents an intermediate state. It represents a sort of stage in between decolonization or independence or self-determination of native peoples, because it was seen that there is some kind of failure on the part of these peoples to be able to deal with the strains, the strenuous realities, the strenuous conditions of the modern world, if we are to quote Article 22 specifically. And this represents then the classic production of the so-called white man's burden, the sense that the so-called civilized had almost a moral duty to support and to look after the backwards, the undeveloped, the uncivilized peoples. They, according to the League of Nations, needed guidance, they needed support, they needed encouragement. Conveniently, this modality of support would be perpetuated through a legitimated form of colonial control and domination, established through an international organization. It's quite convenient for those imperial empires that still existed, Great Britain, France, for example, that they would essentially take on the so-called white man's burden through this basically soft form of colonial control and domination that is legitimized through an international organization. According to Mivel, Article 22 was an admission that they could learn. The natives, it is claimed, have not yet learnt to stand by themselves. These categories through which the mandates were conceived undermined them by containing their own end. So fundamentally then, this question of colonialism will continue to exist, and it will continue to take place throughout the interwar periods. In addition to the continuation of colonialism by another name, Article 22 of the Covenant also introduced a sort of tiered system for the mandates. The mandates didn't just exist as one major system, it was actually divided into three different systems, three different tiers of mandates. The three tiers mandates looked a little bit like this. You had Class A mandates, which represented former Ottoman Arab territories in the Middle East that were considered to be closest to independence. And this included things like the mandate for Palestine, the mandate for Iraq, the mandates for other parts of the Middle East as well. And some of them did in fact get their independence. Iraq, of course, gets its independence in the 1920s, I believe. Class B mandates were part of the former German colonies in Africa and were seen as requiring more control. They were not seen as being quite close to independence yet. They needed more colonial overreach and oversight. And then finally, Class C mandates were former German territories in specifically Southwest Africa and also the Pacific. Again, also seen as mandates that needed more and more direct control because they weren't viewed as being able to govern themselves in any meaningful way. And so within this system, the quote-unquote mandatory powers, the colonial powers that would essentially take on the mantle of the mandates, that would control these territories, Great Britain and France specifically, were responsible for administering the mandates, for ensuring well-being and development for the inhabitant population, and to also, quote-unquote, prepare them for self-rule. The type class mandate that we're talking about would basically indicate how much preparation, quote-unquote, would be needed for these regions to actually be able to be granted self-rule. More broadly then, the League of Nations. Let's just think about the League of Nations, because why did it fail? What are the reasons why it failed? Because it seems to have a lot of the same kind of structures as the United Nations has today. It does. It has things like the Permanent Court of International Justice, it has an assembly, and it has a council that act in a similar kind of way, not exactly the same, but in a similar kind of way to the UN General Assembly and to the Security Council. Well, despite its ambition, the League of Nations was hampered by a number of really significant issues. So, firstly, the most important of these early significant issues is the fact that the United States fails to join. the League of Nations did not, in fact, manage to win over the support of the US Congress. The US Congress was, the Senate specifically, was particularly concerned with some specific provisions that were seen to be potentially overly burdensome. So provisions concerning the sort of territorial integrity of states and the sort of if there is a failure for the respect of that territorial integrity, it might bring other League members to have to involve themselves militarily in supporting their territorial integrity. And the Senate didn't quite like that. And given the fact that, according to the US Constitution, in order for a treaty to actually be ratified by the United States, it requires the consent of the Senate, this was a major problem. The US did not join the League of Nations. When put to the legislature by Woodrow Wilson regarding membership, the Senate refused to ratify the covenant. What followed from the perspective of the United States was essentially a 2-decade period of relative isolationism from world politics. They sort of insulated themselves away from the rest of the world. They didn't really do that much. They didn't completely isolate themselves, but it is sort of a period that is known as isolationism for the United States. It's a period that is also represented by quite a lot of internal domestic developments. You have the sort of Roaring Twenties. You have Prohibition and its revocation. You have the Wall Street crash, which we'll get to in a second. The Great Depression in the 1930s, and really the US comes back into the international sphere in a major way only in 1941 when they join the Second World War. And from there, they become much more heavily involved in international affairs. Additionally, other countries, such as the Soviet Union, the newly founded Soviet Union, nor Germany, they were also absent from the League for the majority of its duration. Germany and the Soviet Union would later join the League of Nations, but then they would leave again not long after they join. At least at this initial juncture, at least as the year 1920 rolls around and the League of Nations is finally opening its doors for the first time, countries like the Soviet Union, countries like Germany, countries like the United States, importantly, are not able to join. They are not part of this new international organization, severely hampering its effectiveness. In addition to the failure to entice major powers, the League was also often hampered by a number of its sort of constitutional requirements. So the constitutional requirement for unanimous decisions among its members in the Assembly specifically was difficult, given that such a system inevitably led to deadlock, and it was an approach which made decisive action on major issues very difficult to achieve. This would be worse in circumstances where, of course, national interests of member states would conflict with the collective goals of the League itself. So if there is one country that has a national interest in maintaining the status quo, but the rest of the League believes that it is important for there to be some kind of major reform, it doesn't really matter because it requires unanimity. And so this unanimity requirement means that they could essentially deadlock the entire League of Nations and stop them from even getting about any kind of major reforms. Furthermore, where decisions would need to be taken, there is a lack of enforcement mechanism. The most powerful deterrent mechanism really was through economic sanctions. But because states like the US were not involved, and therefore were not obliged to adhere to these economic sanctions regimes, they were rendered relatively ineffective. If, for example, there is economic sanctions imposed by the League of Nations, but you could, as a country, just go and trade with the United States because they're not obliged to adhere to those sanctions regime, then you're going to undermine the enforceability of the rules that you are setting within the League of Nations itself. Ultimately, though, these are teething problems compared to what ultimately happens in the 1930s. So 1929 rolls around and we get the Wall Street crash. The Wall Street crash culminates in the Great Depression and brought more and more states towards totalitarianism and fascism because of the economic difficulties associated with, at the time, the world's worst economic crash in history, essentially. Political ideologies would both conflict with the League and also would desire their own territorial expansion, which in turn would also conflict with the League. This is where the League of Nations would truly fail, because it ultimately fails in preventing aggression by its very aggressive members. For example, in 1931, Japan invaded Manchuria. This was a decision that went effectively unchallenged by the League of Nations. They issued something known as the Layton Commission and the Layton Report, which said all the right things but was very, very delayed. It didn't really recommend anything that would have any kind of teeth, and ultimately the Japanese delegation would storm out of the assembly and formally leave the League of Nations not long after the Manchurian crisis. In addition to this, when Italy invaded Abyssinia, modern-day Ethiopia, in 1936, we can see that a similar thing happens. A lack of response came from the League, and then Italy unilaterally withdraws in 1937. All of these things were rumbling in the minds of other authoritarian dictators during this time period. So, for example, Germany would leave the League of Nations in 1933, and when we think about the rise of Adolf Hitler in the late 1920s, early 1930s, the establishment of the Third Reich as a new regime, this becomes a major problem because Hitler is looking at the Manchurian crisis, Hitler is looking at the Abyssinia crisis, and is seeing that the League is not doing anything, and that the League is basically unable to do anything. And Hitler has his own ambitions. He wants to erase the Treaty of Versailles. He wants to unite German-speaking peoples across Europe. He wants to establish what is known as Lebensraum, living space, in the East. And in doing so, he starts to challenge a number of basic provisions of A, the League of Nations, and B, the Treaty of Versailles. One of the terms of the Treaty of Versailles was that the Rhineland, the area west of the River Rhine, on the west bank of the River Rhine, would be demilitarized, essentially creating a bit of a buffer zone between Germany and France. In 1936, while the whole world was looking at the Abyssinian crisis, Hitler rearms and remilitarizes the Rhineland. On a Saturday morning, they storm into the Rhineland, and it goes completely unchallenged by the League of Nations. In 1937, 1938, we see the annexation of Czechoslovakia through, firstly, the Sudeten crisis, and then secondly, through the full annexation of Czechoslovakia as well. In 1936, we see the Anschluss with Austria, a unification with the Austrian-speaking people, with Austrian peoples. And then on the 1st of September 1939, we see the invasion of Poland, which ultimately is the final act that represented the nail in the coffin for the League of Nations, and it also represented the final act that Hitler could get away with before there would be any kind of military repercussions. Essentially, the sovereignty of Poland was respected and represented as an ultimatum for the Allied powers, for Great Britain, and for France, such that if Hitler was to invade Poland, which everybody knew that he was going to by this point, it would invoke a world war. And that's exactly what happened, which triggered the beginning of the Second World War in Europe. Despite this, though, the League of Nations does have some notable achievements. I don't want it to be seen that the League of Nations was just a complete failure from beginning to end. It does have some notable achievements. It worked very well to end and to free hundreds of thousands of slaves in certain parts of the world. It was relatively successful in a number of World Health programs, such as the helping and the development of the eradication of polio around the world. It also repatriated a number of POWs and refugees from the First World War. And its judicial branch for international lawyers, the Permanent Court of International Justice, remains a very important institution. Many of the judgments still bear some relevance to this day. And many of the basic principles of the PCIJ remain important for the work of the successor to the Permanent Court of International Justice, which is, of course, the ICJ, the International Court of Justice. Additionally, the League's shortcomings highlighted the need for a more robust international organisation. It might have been the case that if the Second World War never happened, the US might never have joined an international organisation like the League of Nations or the United Nations. the United Nations might not have been the institution that it is today, one of the longest lasting and most impactful, without the work of and the ultimate failings of the League of Nations. Now, it's a very harsh price to pay, given that it required a world war, a second world war, and a number of horrific atrocities that take place therein for this to take place, to take shape. But it's perhaps why we have seen something of a reconceptualization of the years of the League of Nations in recent academic literature. Quoting again Suvala, quote, "The League of Nations has been synonymous with failure and irrelevance, not least because of its gradual demise during the 1930s and its failure to prevent the Second World War." Nonetheless, in recent years, there has been a revival of interest in the interwar period and a reassessment of the legacy of its institution. So ultimately, if we were to sort of conclude the League of Nations did fail. The main thing that the League of Nations was supposed to stop was another world war, and it failed to do that. But that's not to suggest that every single part of the League of Nations was a failure. But from now, let's think about some other more developments that we see after the failure of the League of Nations. The Second World War remains the single most important event in all of human history, certainly in modern history. It is also simultaneously the single worst event in all of human history, and hopefully will continue to be the single worst event in all of human history. Coupled with the logical extension of fascism, that being genocide, the Second World War did more to shape the landscape of international law than any other event, in my opinion. The very outbreak of the Second World War itself was a representation of the failure of the international legal system at that time. It encapsulated the complete and utter failure of the League of Nations. One of the key rationales, as I've already mentioned, of the League of Nations was the establishment of a system to resolve disputes peacefully without the need to resort to war. Given that the Second World War was also the largest war in human history, it's fair to say that the League of Nations failed miserably in terms of that raison d'etre. Now, during the Second World War, between 1939 and 1945, it became clear that it became clear that a new set of international rules was going to be needed for when this war was over. Now, at least in the early stages of the Second World War, it wasn't clear who was going to win, but by the end of 1941, going into 1942, it was very clear that with Germany making two catastrophic military mistakes, firstly invading the Soviet Union in June 1941, and secondly declaring war on the United States in December 1941, it became very clear that Germany was not going to be able to win the Second World War. Now, looking back from a historical perspective, Germany was never going to be able to win the Second World War, but at least during the 1940s, in 1939-1940, it seemed that they were unstoppable. But fundamentally, it became very clear that there was going to be a need for a new system of international law when this war was over. And one of the earliest instances of this taking place was actually in June 1941, with the Declaration of St. James's Palace. This was one of the first ever Allied statements envisioning post-war cooperation. It was also a pledge of solidarity in fighting against aggression, and the declaration proclaimed that, quote, "The only true basis of enduring peace is the willing cooperation of free peoples in a world in which, relieved of the menace of aggression, all may enjoy economic and social security." Later that year, an agreement between the US President F.D. Roosevelt and the UK's Prime Minister Winston Churchill spawned what became known as the Atlantic Charter. This was before, in fact, the United States had formally joined the war, the Second World War itself. And it was also when the Third Reich was tearing its way through the Soviet Union. The Atlantic Charter essentially declared and affirmed a number of basic principles of human rights, which included the right of every people to form their own government, the right of equal access to raw materials, and the right for peoples to express territorial changes without having said changes imposed onto them by force. This was also the establishment of self-determination, which was originally elucidated all the way back by Woodrow Wilson in 1918 with his 14 points. If we see, for example, the work of Fitch, he says, quote, basically the Wilsonian view of self-determination as self-government was maintained, as exemplified in the Atlantic Charter of August 1941 between the United States and Britain, and afterwards signed by most Allied powers. The Charter only promised restoration of conquered territories, it did not cite self-determination. So we can see a sort of caveat that we have to think about as well, the sort of restoration of conquered territories, but it fundamentally is representative of this Wilsonian idea all the way back from the principles of the 14 points back in 1918, even if it did not specifically cite the words self-determination. After the United States was attacked at Pearl Harbor in December 1941, the formal decision to join the war was made, and on the 1st of January 1942, the Declaration by United Nations was signed. The Declaration by United Nations was a declaration, as the name suggests, which was signed by 26 Allied nations, with a pledge to fight against the Axis powers. This is significant because it was the first time anybody in a formal setting, in a formal declaration, coined the phrase United Nations in this context. But it wouldn't be until 1944 that the more formal process of establishing an organization that becomes the United Nations would take place. This becomes known as the Dumbarton Oaks Conference, and it takes place between August and October 1944. At this point, the war's victory is a mere formality for the Allies, and so they convened at the Dumbarton Oaks Conference, which took place in Washington, D.C., and the so-called Big Four, the United States, the United Kingdom, the Soviet Union, and interestingly China, that is often left out of these conversations, came together to draft the blueprint for a new global organization. The importance of China in these meetings is very, very interesting and somewhat contradictory. Firstly, China is an allied power during the Second World War. China suffers a great amount of loss during the Second World War, with the Second World War for China beginning in 1937 with the Second Sino-Japanese War, and suffering a loss of life that can only be compared against that of the Soviet Union. And on the one hand, China's involvement as one of the quote-unquote Big Four represents a major step in the growth of China as a global power. To quote Tang, for example, quote, besides concerning itself with international law, China's participation in this conference signaled its status as one of the Big Four. Furthermore, this significantly helped China to become a permanent member of the UN Security Council. So if we remember to our understanding of the United Nations, which we'll get to in a second in more detail, there is, as part of the Security Council, permanent members, the P5, 5 permanent members of the Security Council, and China is one of them. And it is precisely because of its involvement, China's involvement in these different organizational conversations, that brings China into the fold as a permanent member. However, we should also be cautious to sort of couch this language with the sort of pragmatic realities, because when we quote Tang again, in fact, Britain, the Soviet Union, and the United States decided everything in the first phase, where China was not invited, of the meeting from the 21st of August to the 28th of September at the Dumbarton Oaks Conference. China was only permitted to attend the second phase of the meeting from the 29th to the 7th of October with America and Britain, which only confirmed decisions already taken in the first phase. So there's a sort of double-edged sword to China's involvement, intervention, contribution to these early stages of the United Nations. On the one hand, they were part of the so-called Big Four, but on the other hand, the Big Three, the British, the Soviets, and the Americans, were the ones that were making most of the big decisions. The United Nations, then, was established in a transitionary phase from war to peace during the Second World War. A lot of the groundwork for the creation of this new international organization would take place in the latter years of the Second World War. We have, for example, the United Nations Conference on International Organization, which took place between April and June 1945. It was here that, in San Francisco, 50 countries would work together to finalize what would be known as the Charter of United Nations, the UN Charter. The UN Charter itself would then become ratified and signed on the 26th of June 1945 and would then enter force on the 24th of October 1945, the formal establishment of the United Nations taking place along this timeline. The Second World War, for reference, ends in Europe in sort of May 1945 and then ends in the Pacific in the first week of August 1945 after the top dropping of the atomic bombs and the Soviet invasion. Now, the structure of the United Nations was slightly different to that of the League of Nations, but it's very easy to overlook this. It's very easy to overlook the similarities specifically because there were similarities, and this is one of the things that we should think about when we examine the legacy of the League of Nations. Because there are similarities, and it's the legacy of the League that, of course, informs some of the structural decisions that are made about the United Nations. Firstly, the United Nations ensured the inclusion of major powers within its organization. This is very, very important. It would not fail where the League of Nations failed at securing the patronage of major powers, like the United States and the Soviet Union, for example. The United Nations instead was founded with the participation of all of the major powers. It was especially important for the emergence of this new post-war power structure, the emergence of the two new superpowers, the United States and the Soviet Union, at the end of 1945. The global landscape that we see at the end of the Second World War is very different to that of the end of the First World War. One of the first major issues is that decolonization becomes a necessity at the end of the Second World War. And throughout the coming decades, this would take place. It would take place in major steps in the 1940s. You have, for example, the removal of colonial interests in places like the Middle East in the 1940s. You also see the independence and the partition of India and Pakistan in 1947. We then start to see the gradual decolonization of various other parts of Africa and other parts of East Asia and Central Asia throughout the 1940s, 1950s, 1960s, and the 1970s, in fact. At the same time, the world in 1945 is increasingly bipolar. And what I mean by this is you have two global hegemonic power structures that exist in competition with each other. Since these are two power structures that are intimately involved in the working and the creation of the United Nations, the two powers that are listed on screen here, it gives the United Nations a certain sense of success that the League did not have. In addition to this, we can also see that there is the establishment of the Security Council, which, as I've mentioned, act in a similar way to the League of Nations Council, but had a number of different features. The structure of the Security Council is very, very important because it would have 5 permanent members. It would have the United States, the Soviet Union, France, Great Britain, and China as the permanent members that would all have the ability to veto resolutions. The only change from the establishment of the UN to today in terms of the permanent 5 is that the Soviet Union no longer exists, but has been replaced by and succeeded by the Russian Federation that is currently still a permanent member. It also gives an incentive for major powers to engage in the system, the system of the United Nations as it was intended, since those major powers have a disproportionate level of power and influence that they can wield from within the United Nations. It hopefully gives them the ability to, or the desire or the motivation for them to engage within the system of the United Nations, rather than feeling the need to achieve foreign policy aims via alternate means, i.e. Separate diplomatic negotiations, or even acts of aggression and acts of war. Also within the Security Council, there was the establishment of a collective security architecture which allowed for effective enforcement. This is seen in Chapter 7 of the UN Charter and grants the Security Council the authority to make binding decisions, including decisions which concerns issues on things like the use of force or the use of sanctions. This is an enforcement mechanism which provides the UN with far more power than the League of Nations ever had. So this is the establishment of the United Nations. But also in the post-war world, we see the establishment of other institutions. And I want to spend a brief amount of time talking about this idea of post-war justice and thinking about the Nuremberg trials. So, one of the most famous institutions that emerges at the end of the Second World War is, of course, that of the Nuremberg Tribunal, the International Military Tribunal at Nuremberg. The Second World War means a lot of things to a lot of people. To many, it was the embodiment of cruelty and crimes against humanity. A theme which permeates anyone's study of the Second World War is, of course, the Holocaust, the systematic extermination of around 6 million of Europe's Jews by the Third Reich, as well as other crimes committed against other minority groups across all of Europe. The significance of the atrocity called for international condemnation, and it called for a sense of justice for the many millions of victims who were lost. And so it was decided that a series of military tribunals would be established to deliver justice to those who had perpetrated these crimes, or to as many of them who are still alive and around who perpetrated those crimes as possible. They would later become known as the Nuremberg trials, of course, owing to their location, the city of Nuremberg, where they would be overseen by each of the Allied powers in the war. Now, one of the key issues immediately to cut through is this idea of individual criminal responsibility. This is a principle of international criminal law that is vital for its effectiveness, for its efficacy, and is also vital for the efficacy of the Nuremberg trials. These tribunals were established under the London Charter, which was an international agreement and had character of public international law. It was a public international law instrument. However, despite this, the main substance of the Charter was that it was going to apply to individuals involved in these acts, not to states. It became very clear, and a very important precedent that was established at Nuremberg, that it's not just states that can be found to have acted in violation of international criminal law. It is also individuals, people who actually carried out these atrocities. And this gives rise to this notion of individual criminal responsibility for international crimes. What are the international crimes, you might say? Well, these are identified in the London Charter and are cited as the jurisdiction of the tribunal. So we have, for example, crimes against peace, war crimes, and crimes against humanity, as well as, in addition to all of these, conspiracy to commit any of the above. That is cited as a sort of fourth crime that is cited in Nuremberg, in the London Charter. Now, 2 points should be referenced here. Firstly, contrary to popular opinion, the Charter did not include the crime of genocide as prosecutable under the jurisdiction of the tribunals. There's a few reasons why this is a thing that is often cited as existing as part of the Nuremberg trials. One of the reasons is because the prosecutors at Nuremberg would consistently reference the phrase genocide and use the word genocide throughout, but it was not part of the indictment for these crimes. This was something that the creator, by the way, of the crime of genocide, the Polish lawyer Raphael Lemkin, had rallied to include in the London Charter, but to no avail. Genocide was not included. If you want to know more about this, there is a whole book by an international lawyer by the name of Philippe Sands called East West Street on the Origins of Genocide and Crimes Against Humanity. It's a very, very interesting read, and it gives a detail about the sort of the tussle, the sort of dichotomy that exists between genocide and crimes against humanity, and between the international lawyer of Raphael Lemkin and that of Herschel Ottopacht in terms of the sort of the advocacy for crimes against humanity versus genocide. The second point of note that I was going to mention here is that it's very interesting that the crime of aggression, defined as crimes against peace, was included in the Charter. This is interesting in the sense that it was an addition to the IMTs, but would remain absent from the lexicon of international criminal law for a great many years, and it wouldn't make its way back into the sort of lexicon as a crime as part of international criminal law until the 2000s, with the addition of the crime of aggression to the Rome Statute, which we'll get to in later slides. The Nuremberg trials themselves are divided into two main parts. So the first were the trials dubbed the Nuremberg trials, the main bulk of the things that we often refer to as the Nuremberg trials, and that the picture that was on screen earlier cites. These took place between the 20th of November 1945 and the 1st of October 1946. And they involved 24 high-ranking officials of the Third Reich who were indicted. Unfortunately, for those who believe in international justice, the largest figures within the Third Reich, people like Himmler and Hitler, had all escaped justice by either being killed or taking their own lives. And so we see 24 high-ranking officials instead, who are still very high-ranking in terms of their connections to the Third Reich, and definitely were convictable for various different international crimes, but they weren't the Hitlers or the Himmlers of the world. Of the 24 original defendants, there were 19 convictions and there were 3 acquittals. Of the 19 convictions, 12 would be sentenced to death, the rest being subjected to long prison sentences. The death sentences were carried out on the 16th of October 1946, and the only notable exception to this entire story was that of Hermann Göring, the former head of the Luftwaffe, the Third Reich's Air Force, who had taken his own life the night before the execution was due to take place. This was the main Nuremberg trials, but there was also a second stage in the process. These were the subsequent trials. Now, the subsequent trials were held between 1946 and 1949 and included a number of trials on the basis of different acts committed during the Second World War. You have, for example, the doctors' trials for the unlawful use of medical experimentation, as well as the Nazi T4 program. The T4 program was a sort of euthanasia program. You have the Einsatzgruppen trial, which was for the mass killings by mobile death squads. Essentially, the Einsatzgruppen were a series of, I believe, 5 major battalions that would essentially follow behind the Wehrmacht during the invasion of the Soviet Union, and they would go around essentially executing Bolsheviks, they would execute Jews, they would execute anybody who was seen as part of the sort of intelligentsia, and would carry out genocidal acts in Eastern Europe, contributing to the deaths of around 500,000 people. It was only because of the inefficiency and the psychological problems caused to members of the Einsatzgruppen squads that we start to see the establishment of a more systematic and more efficient method of killing, which is, of course, the use of the gas chambers and the death camps, which will only come into practice after the Wannsee Conference in early 1942. And sort of contributes to the global development of the Holocaust as the crime that it eventually becomes. And you also have the high command trials for the trials of senior military leaders. So what is the legacy of the Nuremberg trials? What can we say about them? Well, firstly, it sets the precedent for the establishment of a new body of international law, international criminal law. Now, while international criminal law sort of existed as a type of legal adjudication prior to Nuremberg, with things like the crime of piracy, being quite old in and of itself, the way in which we understand international criminal law today, the kind of things that we understand about ICL today, really has its origins in places like the Nuremberg trials and the subsequent Tokyo trials that take place as a result of Japanese atrocities committed in the Pacific. Despite taking a real absence during the Cold War, with the fall of the Soviet Union and the ethnic conflicts that we see in the former Yugoslavia and Rwanda in the 1990s, which we'll get to in future slides, we can see that the body of law that is ICL becomes very, very important, and the legacy of Nuremberg provides an avenue for that legal administration of these different kinds of issues. Nuremberg is also vital because it also provided a method for documentation of the crimes of the Nazis. It helps provide a historical record, education, and memorialization of the Holocaust, all of which is very, very, very important. But the legacy of Nuremberg is not necessarily a perfect one, because many almost immediately would critique the tribunals as being an example of victor's justice, i.e., a violation of the basic principles of the rule of law. The argument goes a little bit like this. One of the things, one of the charges that was provided in the indictments is the crime against peace, as I've mentioned. This is a crime that was only codified after the end of the Second World War, i.e. specifically through things like the UN Charter. So defendants at Nuremberg were able to argue that this was a retroactive law, that you are essentially applying these new laws that are developed after the Second World War to events that had taken place before and during the Second World War. And then when you couple this with the fact that only the indictments that came were against Axis powers, and nothing committed by the Allies was put to the tribunal, the crimes, for example, like the Katyn massacre in the Soviet Union, or in Poland specifically, and Allied war crimes, you do get a view that the Nuremberg trials might be seen as unfair or somehow impartial, or non-partial, should I say. Now, obviously, not many people are going to sympathise with this, given the fact that you are arguing for applying rule of law to Nazis who carried out the Holocaust. But fundamentally, this does raise some interesting questions about the legacy of Nuremberg. But the thing you can't say is that these crimes didn't exist after the Nuremberg trials, which is, of course, why the legacy of Nuremberg is so important. Because it provides us then with a legal justification and a sort of framework, a sort of architecture for the establishment of these international organizations, with things like the Yugoslav Tribunal and the Rwandan Tribunal, and then ultimately the International Criminal Court in the 1990s. So, following the Second World War, we immediately get divulging into the Cold War that takes place from around 1945 all the way until 1991. Now, the Cold War represents one of the most interesting time periods. From the perspective of international relations, so not thinking about international law, but international relations for a second, the Cold War sees the emergence, should I say, of two global hegemonic superpowers that then establishes what we know to be a bipolar world. These were the United States and the Soviet Union, the USSR. And roughly between 1945 and 1991, this was an epoch of intense political and ideological divide. An ideological divide that existed between the capitalist West and the communist East. This Cold War has two main implications, as I could identify, for the development of international law. The first of these is the fact that it brought states into ideological blocks. So you sort of have the communist bloc and the capitalist bloc, with there being relatively little cross-cooperation between the two main rivaling ideologies. You sort of have the ideologies of the Warsaw Pact and the sort of Sino-Soviet relations between the USSR and China, and then you have the West, the establishment of the European Union, the establishment of NATO, and all these different organizations in the West. But another interesting fact is that where international law does develop, and it does develop at a slower rate during the Cold War, but where it does develop is in the way that it creates a sense of focus on specific issues of Cold War concern. What do I mean by this? Well, the Cold War is characterized mainly by this international rivalry between East and West, but also the looming threat of nuclear war, given the fact that both the USA and the USSR had developed nuclear weapons quite early on. The USA obviously developed them in 1945 with the Los Alamos project, and then the USSR, not long afterwards, a few years later, would develop their own nuclear weapons. And so this overarching threat of nuclear war that threatens to destroy the whole world was very much in the air for a great amount of time during the Cold War, especially moments of peak, like in the 1960s with things like the Cuban Missile Crisis. And so what this does is it creates a sense of focus, in the sense that international law is now focusing on issues of things like disarmament and arms control and non-proliferation of nuclear weapons, things that are definitely of Cold War concern, should I say, in inverted commas. And so what we see here is that a system of international law becomes relatively stagnant during this time, especially compared to the immediate aftermath at the end of the Second World War. And we can see this in the ways in which, for example, the UN Security Council operates. Quote, legally, their rivalry, the rivalry between the US and the Soviet Union, with Great Britain and China also chiming in as well on the Security Council, their rivalry actually paralyzed the UN Security Council, owing to crisscross votes. The crisscross vetoes specifically, should I say. Eventually, the bipolar system was somehow challenged by the non-aligned movement, a group of developing countries that considered themselves not formally aligned with or against any major power bloc. This is a development that is often not cited as being important, but it is very important, that during the Cold War, you have East and West, and then you have a sort of third movement that begins to grow, the non-aligned movement. Countries like the country of Yugoslavia, for example, many countries in the Middle East, like Egypt, become part of this non-aligned movement that sees themselves as not being part of the West or the East, as sees themselves as being independent, not formally aligned with or against any major power bloc. Although it should be noted that many of the members of the non-aligned movement ultimately find themselves within the broader Soviet sphere of influence, despite saying and claiming that they are not formally aligned with any major power bloc. So international law is relatively stagnant during the Cold War, but there are some developments, and I'm going to spend the next slide thinking about what those developments look like. The first we can see is in the field of human rights, international human rights law. We finally see, for example, the implementation of the Universal Declaration on Human Rights. The UDHR is an important document that was established in the 1940s, but it is not a legally binding document. It is the Universal Declaration of Human Rights. It's not a treaty, it's not a convention. And so it was adopted just as the Cold War was getting underway, but provided a base point for both sides to claim legitimacy in terms of human rights protections. But its implementation into actual treaties that could then have actually legally binding status and could actually be able to provide human rights to individuals around the world would have to come later on, and would come later on with the ratification of both the International Covenant on Civil and Political Rights, the ICCPR, as well as the International Covenant on Economic, Social and Cultural Rights, the ICESCR. These become known as the sort of twin covenants, and are both adopted in 1966 and would come into force a decade later. The importance of the twin covenants is that they reflect the practical realities associated with the implementation of human rights. Because while the UDHR was seen as a sort of revolutionary declaration on human rights on an international level, the actual legal application of said rights would require the implementation over further decades. The actual difference between declaring human rights, the UDHR declares the existence of these human rights, and then actually rolling up your sleeves and implementing those as an actually enforceable, legally binding set of treaties, are two different matters and clearly require a lot more time, a number of decades in between each one. The human rights development also embodies the split between civil and political rights on the one hand and economic and social rights on the other, with the Western world during the Cold War being more eager to bind states to civil and political rights, and the Eastern world being more eager to bind states to economic and social rights. Just an interesting development there. Furthermore, we can obviously see that nuclear weapons, as I've mentioned earlier on, becomes a very key point of inflection for international legal development because they become very important, because the threat of nuclear war is just too big to have to deal with. And so, in 1968, for example, we see the Treaty on the Non-Proliferation of Nuclear Weapons. Nuclear weapons, by this point, are a strict reality. It's impossible to develop a system in which nuclear weapons could be phased out of existence entirely, at least at this point in history. And so the best the world would be able to do is try and make its reduction take place as much as possible, reduce the number of nuclear weapons as much as humanly possible. And also to reduce the number of states that have nuclear weapons as much as humanly possible. And the Non-Proliferation Treaty was a framework to try and restrain nuclear proliferation. Non-nuclear states would promise not to acquire nuclear weapons, while nuclear powers would promise to disarm their nuclear weapons and to sort of lower the temperature down on the number of nuclear weapons that existed. The main reflection we can take away from this agreement is that of the existential threat that was posed by nuclear weapons. And ultimately, the sort of framework that is developed and established is this idea of a collective security framework, where countries that are part of, let's say, the Warsaw Pact or NATO would be able to rely on the global power of these nuclear states for their own sovereignty and protection. For essentially, if a country is attacked, if a NATO country is attacked, they can trigger Article 5, which is this sort of attack on one is an attack on all provision. And that brings in nuclear states. And so it reduces the need for these other states to have nuclear weapons, because you can just think about this idea of a so-called nuclear umbrella in which major nuclear states are able to protect smaller states, if need be, by using nuclear weapons. Now, later on in the Cold War, further disarmament and non-proliferation agreements would also take place. There is a sort of period of détente, and then there is a period in the 1980s as well that takes place that sees, for example, the Intermediate Range Nuclear Forces Treaty, the INF Treaty, as well as the Strategic Armed Reductions Treaties, the START treaties. Further developments that we're going to see during this time period is, of course, within Cold War relations. In 1975, we see the signing of the Helsinki Accords, a very important set of documents that were signed by 35 states from both Eastern and Western Bloc countries. So there's a bit of cross-ideological communication here. While not necessarily a treaty in a strict sense, the final act is binding in terms of its political and moral declarations. It combined respect for territorial integrity, as well as the inviolability of borders, as well as the protection of certain human rights and fundamental freedoms. For another development in international law, I want to just spend a bit of time talking about the creation of, during the Cold War, international organizations. So, invariably, this is an area of international law that is, of course, very new. One of the earliest questions that the ICJ had to deal with was concerning the legal nature of the United Nations in international law. What kind of entity was the United Nations? What was it? This is an important question since it speaks to the kinds of rights and duties that the United Nations would be entitled to. The court found, in one of its earliest cases, in the advisory opinion, an advisory opinion on reparations for injuries suffered in service of the United Nations in 1945, that the United Nations is a subject of international law and is capable of possessing international rights and duties, and that it has capacity to maintain its rights by bringing international claims. This is a very important case, and it does set a very strong precedent for the status of international organizations in this newly formed establishment of international law. Now, we'll get to this in more detail when we think about the relationship between states and international organizations, so if you feel like we haven't gone into this in enough detail here, we will do in future lessons' time. But for now, I want to move on to thinking about the 1990s. So as you can imagine, it goes without saying that the end of the Cold War, the collapse of the Soviet Union and the USSR, and the ending of the Warsaw Pact is a pivotal moment in the development of international law. With the collapse of the Soviet bloc in 1989, many geopolitical constraints that had previously existed during the Cold War that we have just mentioned began to loosen. And what this allows for in the 1990s is a surge in multilateralism, a surge in international community between multiple states in creating global organizations. When we couple this with the growth in technology and the driving of globalization in terms of economics, communication, and environmental interdependence, we can see that the 1990s is a period of rapid development of international law. Unfortunately, the 1990s also is a period of severe humanitarian crises, two of which we will look at, but there are others that we could have explored here as well. And the difference is that unlike the Cold War, which also had humanitarian crises, you had, of course, the Korean War, the Vietnam War, you have the Soviet invasion of Afghanistan, you have the conflicts in places like Cambodia, the Cambodian genocide, for example, conflicts between in India and Pakistan and Bangladesh. Unlike those humanitarian crises during the Cold War, the humanitarian crises of the 1990s sparked something more of an international response and showed the kind of things that international law was capable of achieving. I want to begin, though, by thinking about how the United Nations saw the 1990s in 1989, at the point at which we were seeing the turn of the decade. What did the UN General Assembly say about the 1990s? Well, in November 1989, they passed General Assembly Resolution 4423, which declared that the 1990s would be the United Nations decade of international law. It had a very simple aim: to promote acceptance of and respect for the principles of international law, to promote peaceful settlement of disputes, encourage progressive development and codification, and encourage teaching, study, dissemination, and wider appreciation of international law. So they're going into the decade of the 1990s with quite a lot of hope and positivity, as it seems. So in what ways were they successful, or should we say predicting correctly the development of international law? Well, on the one hand, we can see that there is a greater amount of codification of international law than at any other time, except for that of the 1940s and the 1920s specifically. So since the 1940s, the 1990s is the greatest amount of international development of international law. But problematically, this is also a time period where we see major conflicts that require an international response, that requires a sense of international justice. And I want to begin by thinking about the International Criminal Tribunal for the former Yugoslavia, the ICTY. So, as a basic background then to the Yugoslav wars, prior to the 1990s, the country of Yugoslavia was a federation of 6 separate republics. These that were still federated together as part of a single state that was Yugoslavia. These were Slovenia, Croatia, Bosnia and Herzegovina, Macedonia, Serbia, and Montenegro, with the addition of 2 autonomous provinces located in Serbia, the provinces of Kosovo and Vojvodina. Now, political tensions will increase with the death of Tito in 1980. And when we couple the death of Tito, the dictator of the Yugoslavia, with a combination of economic decline, nationalism, and religious diversions, the region would then start to break up and will descend into a variety of conflicts in the 1990s. I'm just going to very, very briefly go over these conflicts. They're very, very complicated, so I'm not going to do it justice enough. There are a number of books that I'll put in the description if you want to read about the history of the former Yugoslavia and the breakup and the Yugoslav wars. But suffice to say, as a sort of brief overview in this already very long lecture, Slovenia would declare independence on the 25th of June 1991. And in response to this, the Yugoslav People's Army, that is abbreviated to the JNA, would attempt to reassert control over border crossings. This was the first instance of what was ultimately relatively brief but localized fighting, and ultimately resulted in the withdrawal of the JNA. So that was the first sort of part of this conflict. That same year in 1991, Croatia would also declare its independence. Ethnic Serb minorities who were supported by Serbia and the JNA within Croatia would start to resist and take parts of the Croatian territories, control of parts of the Croatian territories. A stalemate would begin to ensue, with civilians being displaced and cultural heritage being destroyed between 1991 and 1995. Again, we're seeing a breakout of conflict. The most violent of these episodes, and the part of this conflict that most people will be familiar with individual events taking place therein, was probably the Bosnian War that took place between 1992 and 1995, when in early 1992 a referendum on independence would lead to a declaration of war. We see that within Bosnia, Bosnian Serbs, with the support of Serbia and the Yugoslav army, would resist calls for independence. And the reason why we mention this one is because, of course, this is the conflict where we see some of the worst atrocities of the whole war. So, for example, the siege of Sarajevo takes place in this conflict. So too is the establishment of a number of detention and torture camps, as well as the infamous Srebrenica massacre. Now, again, that's not to suggest that there wasn't atrocities and ethnic cleansing and mass violence taking place in places like Kosovo and in places like Croatia during this time period as well. That definitely was the case. It's just the more famous events that most people in the West tend to know about, things like the siege of Sarajevo and things like the Srebrenica massacre, takes place in this particular part of the conflict. But overall, if we were to summarize the Yugoslav wars, this series of conflicts, should I say, saw some of the worst atrocities committed in Europe since the end of the Second World War. We see the systematic forced removals, the ethnic cleansing, we see sexual violence and crimes against humanity, as well as genocide being committed during these years and during these conflicts. And so the international community would respond. From the perspective of the ICTY, the international community responds with UN Security Council Resolution 827. According to 827, under the powers of Chapter 7 of the UN Charter, we see the establishment of the International Criminal Tribunal for the former Yugoslavia, the ICTY. This was one of the first major international tribunals to try international crimes since the completion of the trials at Nuremberg and Tokyo all the way back in the 1940s. Its jurisdiction included grave breaches of the Geneva Conventions, namely war crimes, crimes against humanity, and for the first time ever in one of these types of tribunals, the inclusion of the crime of genocide. Of course, the crime of genocide has existed for many, many decades at this point. It existed with the adoption of the Genocide Convention in 1948, and so its inclusion as part of the jurisdiction of the ICTY was a foregone conclusion. It was always going to be included in future tribunals of this nature. Now, while a full and detailed analysis of all the cases that we see in the ICTY is well beyond the scope of this lecture, I want to spend a little bit of time talking about a couple of landmark cases, two specific landmark cases. The first is the case of Duško Tadić. Tadić is a very significant case because it is one of the first cases to be tried at the ICTY. It is also significant in the sense that it is one of the first international war crimes trials involving the charge of sexual violence. the importance of including sexual violence as part of these crimes is something that we see coming up a lot in the ICTY, as well as in the Criminal Tribunal for Rwanda as well. And it is these two tribunals that lay a lot of the groundwork for the inclusion of sexual violence in international criminal law subsequent to these particular tribunals. From a legal perspective, of course, the case of Tadic is important for clarifying the delineation between an international and a non-international armed conflict. The definition of a non-international armed conflict is defined in Tadic, requiring a certain amount of intensity and coordination, essentially. And so when we get on to looking at IHL in future lectures, and when we look at international, non-international armed conflicts specifically, we will be citing Tadic as one of our reasons for, or one of our definitions of a non-international armed conflict, of a NIAC. Second case, the case of Konarak et al. Expands the definition of enslavement as a crime against humanity to also include sexual enslavement, and gives a clearer recognition of sexual violence as a crime against humanity against civilians. Again, another very, very important part of this tribunal. Of course, another landmark case is the trial of Slobodan Milosevic, but Milosevic would, of course, die before he actually sees justice, before there is a conclusion to the trial that he is indicted on. Now, in terms of another major event, of course, the International Criminal Tribunal for Rwanda, I'm going to spend some time talking about here. I'm going to spend a little bit of time talking about the Rwandan genocide very, very briefly, and then think about the tribunal itself. So again, as a background to the Rwandan genocide, the country of Rwanda in Africa, prior to the genocide, existed as a colonial holding. It existed first under German rule and then existed subsequently under Belgian rule. Within Rwanda, there are two main ethnic groups, the Hutus and the Tutsis. Now, the use of and the delineation between these ethnic groups are utilized heavily by colonial powers to shape, to harden, and to institutionalize their differences and to stir up racial hatred. There isn't actually that much evidence that there are two major distinct ethnic groups in Rwanda. Most of the sort of differences between Hutus and Tutsis in Rwanda were created by and were sort of exemplified by the colonial powers. Belgium, for example, would utilize identity cards, measurements, and other kinds of markers to try and formalize and to try and sort of entrench the divisions between these two different ethnic groups, and to basically use these groups against each other to try and maintain control. After independence was achieved in the 1960s, we see a shift in political power in terms of the structure of the region. Hutu political dominance would often be accompanied by discrimination and by violence against the Tutsi minority. In the early 1990s, the Rwandan Patriotic Front, which was a group that was largely composed of Tutsi exiles who were living in Uganda, would launch an invasion of northern Rwanda. This invasion of northern Rwanda is very important because it signifies an importance in terms of the presence of the United Nations in this region. A ceasefire would be negotiated with the Arusha Accords of 1993, but the Arusha Accords were a relatively uneasy peace, and a peace in which many Hutu extremists would oppose. The triggering event for the genocide, however, would take place on the 6th of April 1994, when we see the shooting down of a plane carrying the Hutu president of Rwanda and the Burundian president as well. Both of these presidents were killed in the crash. Now, the shooting down of this plane is very, very interesting in the sense that there is no definitive conclusion as to who it was who shot down the plane. Some, of course, blame it on the Tutsis. Others suggest it is the Hutu extremists. What we do know is that within hours of the crash, the Hutu extremists used it as a pretense to launch a series of reprisals, beginning in the city of Kigali with a number of killings of Tutsis and moderate Hutus, but then spreading rapidly across the country. Now, we have a lot of evidence to show that This sort of act of genocide was not something that just came out of nowhere with the shooting down of this plane. Hutu extremists had been importing weapons and had been stirring up violence through various different media and radio transmissions prior to this event. So there is a certain amount of pre-planning that took place. But what we do know is that within 100 days, between April and early July 1994, it is estimated that around 800,000 people were systematically murdered, often with clubs and machetes. These were mostly composed of Tutsis and moderate Hutus, and the international response during the genocide, during the 100 days of genocide, was very limited. The UN was always in Rwanda. The UN assistance mission for Rwanda, which I mentioned was important for the Arusha Accords because they were deployed following the Arusha Accords to monitor the peace process. The problem with the UN assistance mission for Rwanda is that its mandate was weak. It did not allow for a direct and robust intervention, nor did they have enough resources to properly prevent genocide from happening. In addition to the UN assistance mission for Rwanda, there were a number of Belgian UN peacekeepers who were unfortunately killed in the murdering of the Prime Minister of Rwanda, and that then forced and brought the country of Belgium to withdraw the rest of their forces from the region, making it even harder for there to be any kind of prevention of genocide. Now, ultimately, when we think about the UN assistance mission for Rwanda, one of the problems that we have is, of course, they did basically all that they possibly could to try and save as many lives as possible with their limited mandate, their limited resources. And so a lot of the time we don't give the UN assistance mission enough credit for the kind of work that they did, nor do we give the Red Cross the kind of credit because they also never left Rwanda. And the reason for this is because, of course, they were unable to prevent a genocide from taking place. But it's important to remember as well that when we measure the number of lives that are saved by people like the UN Assistance Mission and the Red Cross, it's a very difficult thing to estimate. It's very easy to know how many people were roughly killed. 800,000 were systematically murdered. But it's hard to know how many people would have died had the UN and had the Red Cross not have been present. That's a difficult counterfactual we can't really know. So the sort of, in terms of this specific UN assistance mission, there is, of course, a certain amount of credit that needs to be given. But for the UN more generally, of course, they spend the 100 days refusing to acknowledge the acts of genocide taking place and refusing to intervene in any meaningful sense. The genocide only ends with the Rwandan Patriotic Front gradually resuming military engagements and taking over Kigali in July. And it was only really towards the end of the genocide that the more robust response came from the United Nations and the international community. And this is seen in, specifically, UN Security Council Resolution 955 of 1944, which establishes the International Criminal Tribunal for Rwanda. It establishes the ICTR with jurisdiction over the crime of genocide, crimes against humanity, as well as serious violations of international humanitarian law, similar kinds of crimes to that of the ICTY. There is a greater amount of focus on the crime of genocide in Rwanda, in the Rwanda Tribunal, because this is fundamentally a genocide, whereas in the ICTY there are genocidal acts that take place. And there are but there are also violations of IHL, and there are a lot of war crimes that take place as well. With Rwanda, we're talking a lot about specifically the crime of genocide. Now, again, while there are a number of legal developments that take place, this is a very important tribunal in the sense that it adds a lot of meat to the bones, if you will, for some of the procedural and factual delineations for the crime of genocide itself. So, for example, the Akeshu case in 1998 establishes that rape and other forms of sexual violence can constitute genocide because they will satisfy the actus reus of causing serious bodily or mental harm to members of a group. So even though sexual violence isn't specifically defined in the crime of genocide, it is found there as one of the acts of genocide if it is, of course, committed with the intent to destroy in whole or in part that particular group in question. A further example of a very important case is the Kambanda case of 1998, because this was the first example of a former head of state, this person being Jean-Paul Kambanda, being tried and convicted of genocide. A very, very important case. Of course, a case like the Milosevic case would fail to achieve that kind of conclusion, because, of course, Milosevic dies before he is able to face justice, as I've mentioned already. The work of the 1990s shows essentially that international criminal law is capable of establishing real justice for victims of major international crimes. And it provides the impetus for the creation of a more permanent court that would have jurisdiction over all members who sign up to it, not just having jurisdiction over a particular set of acts within a particular time period. And so in 1995, the United Nations General Assembly creates the Ad Hoc Committee on the Establishment of an International Criminal Court. They'll do a lot of work for a few years, and in 1998, delegations from more than 160 states will come together to Rome for the Rome Conference. And after a 5-week negotiation period, the Rome Statute for the International Criminal Court will be adopted. It will have jurisdiction, at least initially, over the crimes of genocide, crimes against humanity, and war crimes, with the crime of aggression being added later on with amendments in the later 2000s. The statute itself would enter into force in 2002 with the opening of the International Criminal Court in July of that year. And of course, this is a major development in international law in the 1990s that could only really have come about because of the developments of the ad hoc tribunals in the 1990s, as well as the international military tribunals all the way back in the 1940s. I just want to finish the 1990s by looking very quickly, running through some other international legal developments. Again, all of these are areas that I'm going to be exploring in more detail in their own separate series. So when we look at international trade law and when we look at international environmental law, I'll talk about these in far more detail there. But a very quick, in the field of international economic law, we see the major development of the establishment of the World Trade Organization with the conclusion of the Uruguay round for the General Agreement on Tariffs and Trade. In 1994, we see the creation of this new institution, the WTO. The WTO would prove to be, at least initially, and at least for a great many years, a success. It represented a central pillar of international law, and it established a robust dispute resolution mechanism that would not necessarily favour powerful states over weaker ones, something that powerful states didn't quite like, hence why we no longer have such dispute resolution mechanisms. But more on that when we look at trade law in the future. In the field of international environmental law, we can see that there is the 1992 Earth Summit, more commonly known as the UN Conference on Environment and Development, which adopted something known as the Rio Declaration. In 1997, you have the Kyoto Protocol for the UNFCCC, which sets a number of targets for greenhouse gas emissions. It's also an agreement which increased attention to a number of very foundational principles of international environmental law, so the polluter pays principle, for example, and the precautionary principle. Again, more on this in future lessons for international environmental law specifically. And so I just want to conclude by citing again Fossarelli, in looking at the history of international law in the 20th century, by citing the sort of a culmination of the sort of ways in which the world looked like, how the world looked in the fall of the Berlin Wall. And they say, quote, "With the fall of the Berlin Wall in 1989, the ending of the Warsaw Pact on the 1st of July 1991, and the dismantling of the Soviet Union in December 1991, as well as the marginalization of the Global South in international decision-making processes, the West, led by the United States, now the only remaining superpower, emerged as the key agenda setter in the international arena. A belief spread that a new world order based on democracy and the rule of law was surfacing." Now, this idea of democracy, the rule of law, respect for international institutions and the international legal system, of course, sparks all of these different ideas about the so-called end of history, the writings of people like Francis Fukuyama, for example, in the 1990s. With the fall of the Berlin Wall, with the collapse of the Soviet Union, history is no longer, and we're now moving into this world in which unipolarity shows that liberalism ultimately wins and respect for international law ultimately is established. Now, this, of course, will run into a major problem when we think about the early 2000s. And I want to finish on the early 2000s because ultimately, like I said at the start of this lecture, the events that we see in the very modern period, the coronavirus pandemic, the war in Russia and Ukraine, the genocide in Gaza, these are events that I want to think about when we look at the future of international law, because these are events that, some of which are not resolved at the time of recording. So I want to think about them in more detail, future lessons. So I'm going to finish by thinking about the war on terror and thinking about the invasion of Iraq and thinking about the problems that this brings to the global system that we currently live in. Now, ultimately, on the 11th of September 2001, the world will witness a series of 4 coordinated Islamist terrorist attacks against the United States. The attacks were carried out by the organization known as Al-Qaeda, and a total of 19 terrorists would hijack 4 commercial airliners. Of these 4 commercial airliners, 2 of them will be flown into the two twin towers of the World Trade Center in New York, pictured on screen right here. A 3rd will be flown into the Pentagon in Virginia and cause a massive explosion there. And the 4th would never make it to its destination. I believe the 4th was destined to go to the US Congress or the White House, but it would crash in Pennsylvania as the result of a passenger revolt, killing everybody on board. After these attacks, then, the United States initiated its so-called war on terror. It argued for the rights of self-defense in international law against non-state actors, namely the groups who were responsible, and this was in fact the only time in all of history so far that the famous Article 5 collective security provision was triggered by a NATO member. It was triggered by the United States in response to this war on terror. Now, a number of things takes place as a result of the war on terror. The first is the invasion of Afghanistan, and the second is the invasion of Iraq. Potentially the most widespread impact of on international law was this invasion of Iraq in 2003. Now, Suvala ultimately encapsulates the international legal trouble with the invasion of Iraq with the following quote. She says, quote, "On the 20th of March 2002, the United States, the United Kingdom, and their coalition partners launched a military attack against Iraq and quickly overthrew the government of Saddam Hussein. They did so after they failed to secure a UN Security Council resolution that would explicitly authorize the use of force under Chapter 7 of the UN Charter. After this failure, the United States and the United Kingdom justified their actions with a complicated argument involving a combination of UN Security Council Resolution 678 and 687 and 1444, and the assertion that Iraq was in material breach of its disarmament obligations of the ceasefire regime established by Resolution 687. Now, what's really important to recognize is that the invasion and subsequent occupation of Iraq represents a greater threat to the system of international law than most people realize. The legality of the intervention was debated, but the majority of scholars today and international lawyers today conclude that this was an unlawful use of force. And it is these justifications, the justifications for the use of force, that provides the backdrop for some of the problems that we are now facing today in international law. And this is really where I want to finish this incredibly long lecture, because one of the issues associated with debating the legality of the invasion comes from the myriad hodgepodge of justifications presented by the US and the United Kingdom in the first place. According to Critiotis, for example, it's small wonder that Operation Iraqi Freedom, the operation that sought the intervention and overthrow of Saddam Hussein in Iraq. It is small wonder that Operation Iraqi Freedom has earned the ignoble reputation for its cognitive stew of justifications for intervention, or, truth be told, of possible justifications for intervention. Here lies the source of much of the confusion that has riddled assessments of the lawfulness of Operation Iraqi Freedom thus far. A confusion derived from the failure to discriminate between legal and political justifications for intervention and between ascribed and actual legal justifications pleaded in the formal sphere of state action. The importance to realize is that things like Operation Iraqi Freedom, events like the unlawful invasion of Iraq, and the sort of hodgepodge of legal justifications as I've described it here, in an attempt to sort of basically throw as much at the wall as possible or to see what sticks in terms of legal justifications, provides other states, it provides non-Western states with their own legal justifications for their own use of force in aggressive ways. What happens is the unlawful use of force and the crime of aggression taking place under the pretense of some kind of lawful activity. You throw enough justifications, you send a letter to the Security Council that explains using 10 different reasons for why your actions are lawful. You can see that this results in people arguing about the potential legality of an operation that is ultimately just the crime of aggression. And we can see that Western states, Western powers did this in the early 2000s with the invasion of Iraq. And now non-Western states, traditional enemies of the West, let's say, are now using similar kinds of methods, modalities of justifications for their own use of force. Justifications similar in nature, for example, were used in 2022 with the Russian invasion of Ukraine. The Russian Federation, just like the US and the UK, made a hodgepodge number of arguments for invasion. They suggested that collective security for the alleged breakaway states of Donetsk and Luhansk would be a justification for using force against Ukraine. They argued that they were acting under Article 51 of the Charter, i.e. through the provision of self-defense, for some kind of future threat to Russia from Ukraine. They also argued that they were using self-defense in protecting Russian-speaking peoples from the crime of genocide in the Donbass region. Again, throwing a number of justifications against the wall to see what sticks. The State of Israel, similarly, in a very recent action in 2025, through the use of force against the State of Iran, again went to the Security Council with their letter to justify their use of force and threw a number of arguments at the wall to see which ones stick, none of which are very, very convincing, but all of which provides a murky legal world in which people can try and provide a pretense for legality and justification and ultimately render the international system of preventing the use of force a moot point, given that you can essentially throw enough information at the wall and somebody will go out there and try and provide some kind of legal justification for it. But as I've mentioned, those are things that we're going to talk about in future lectures. So I hope you've enjoyed this lecture. I've provided here some sources and citations of sort of broader, further reading on public international law. All of the quotes that I've used are, of course, cited on the screen when I used them. And I'll see everybody back in the future lecture when we start in lecture number 4, talking about the relationship between international law and international relations.